it moving.
Del Walmsley has moved thousands of radio listeners closer to a great life. The Del Walmsley Show is now on in South Florida on Talk 1470, Monday at 5, Tuesday through Friday at noon. Listen and move towards your great life today.
What you want to know. What you need to know.
Talk 1470, WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Yeah.
Hi, everybody. We're sitting here talking about tickets for an event that's coming up. Hey, welcome to Ask the Experts. This is the first Thursday of the month, so that means this is actually really the Kaye Bender-Rimbaum show, and we've got attorneys Robert Kaye, senior partners Robert Kaye and Michael Rimbaum, and I'm not Michael Rimbaum, Michael Bender.
Wow.
And I'm looking at Rimbaum's name here. He's never here.
He's been here, though.
Once.
He's listening. Hi, Jeff.
Hi, Jeff.
Listen, my kids might be
He's
listening.
in the
Can you get
corner.
my name right?
Mr. Bender.
Thank you.
Senior partner.
Mr. Bender.
Big smile, always wears good-looking suits. Sure embarrasses me. You know what? We've already got a phone call already. We just went on the air.
Well, whoever's on, just
You want to
hold
go
one
to
moment.
You want to go to the phone call, or do you want to?
Well, we should say
introduce-
who we are and
Well, we
why
just-
we're here.
Let's have our opening.
Okay, so Pam, just hold a minute. This is probably one of my favorite shows, which is really hard after doing a 3-hour morning show. But it seems like every month I learn something new, and we've got such a great firm here. And we get phone calls. If you'd like to call us here, the phone number is 888-565-1470. And you can also listen to us on 95.3 FM on your way home. We've got here in studio, live, Robert Kaye and Michael Bender. Tell everybody about your firm. He does it with such...
Oh, I'm too.
You
You
know,
want me to?
He liked it.
Hello, hello,
First, a
Steve.
shout
How
out
are
to
you?
Andy Black.
Just in general, and to Mr. Rimbaum, and to everybody at KBR. Well, listen, it's great to be here first Thursday of the month. Pam, thanks for calling. We'll be right with you on the call. Kaye Bender-Rimbaum, Community Association lawyers. We have been practicing community association law so much so that we're good at it now.
Only one of the
Consistently
biggest in the
since
state.
1992, when Mr. Kaye started up the firm. And in that capacity, we act as general corporate counsel for about 1,000+ communities in the state of Florida, primarily Tri-County, Miami-Dade, Broward, Palm Beach, but we do go in other areas of the state. And we're general corporate counsel, soup to nuts, everything that you need. Your community association is a business. Some are small, some are large, some are in between. We assist them from 5 units to 5,000 units with addressing the legal needs of the corporation. Whether it's assisting
entails
them
a
with,
lot.
it's assisting them with enforcing their covenants, or ensuring people are making their payments, collecting collections of assessments, to interpreting and updating their governing documents, drafting contracts, negotiating contracts, addressing if we have to do litigation matters. We have experienced litigation teams doing construction defect, breach of contract, covenant enforcement. I mean, if you name it, it's something that we touch upon almost daily. And we pride ourselves on customer service. In addition to being very good at what we do and knowing the areas of the law and do a ton of free education, which we'll talk about later, our customer service aspect it's what I think separates the firm from the other firms that do what we do, which is that we are accessible, we are responsive, we provide opinions that are understandable. We're not a nickel-dime operation. I mean, these basic tenements of customer service. Which we feel is lacking in many. We hear from other communities that it is lacking, and we're proud to be able to bring the service and, like I said, the free education. So that's a quick and dirdy. But I know we have a few callers.
He won't say
so
it, but they're one of the biggest in the state, and there's a reason for that. And you'll listen when you hear the show today. They make it so easy to understand. We're going to be taking phone calls, and we've already got a lot of calls. Wow, we got another call, and we're going to try to get to people's text that we got this week, Twitter and Facebook. So
Social media is blowing up.
Yeah, it is.
Well, listen, it's free legal advice. Although this is for informational purposes only, right?
Yes, right. He's in a good mood today. Anyway, let's go to Pam. She's been holding for a while. Hi, Pam.
Hi, thank you so much for taking my call.
Good, thanks for holding.
Sure, no problem. I have a couple of questions. I am in Broward County. I am a condo owner, and most recently, our board of directors has donated political money to a candidate. This was not voted on, and I would like to know your opinion on this action. And secondly, we would like to try to understand the process for getting an independent audit done on the board spending of the owner's money. I'm not sure which direction we need to take. And possibly, if you can take a third question, what can you recommend on looking at our financials in an HO6 assessment that we were assessed early last year due to Irma? We cannot see any of this money in our normal monthly financials. They say it's in a different account, but yet we aren't privy to that information. So I'll let you try to answer those for me, and I appreciate your time.
Well, don't hang up, because
Hold
we
on.
may have questions for you and to
Sure.
get through your several questions. Now, the first one, if you wouldn't mind repeating it again. I didn't write down your
The
question.
donations to the political
Political
party.
Political donations, yes. Political donations are generally not considered an appropriate association expense, although you will need to review your governing documents, your declaration of condominium, to see the manner of common expenses, if they're defined in such a way that could allow for it. In general terms, it's typically not considered an appropriate association expense, but there can be situations when the documents will provide sufficient authority. So
Right.
I can't tell you yes or no based on just what you've
Right.
said. So the documents need to be reviewed relative to that.
And we do know our documents fairly well, unless there's some amendments that have made this change. There is none. So what's our course of action?
Well, your course of action would be the easiest and least expensive to you as a unit owner would be to contact the Division of Condominium and indicate there may be a financial irregularity by the association in making political donations without documentary authority. And they will investigate and have the association provide them an answer, and then let them know whether or not that would be an improper act on their part.
And that division of condominium you're referring to is DBPR?
Well, it's within the DBPR, but it
Okay,
is
okay.
specifically for condominiums, and there is a Fort
Okay.
Lauderdale office that you can contact.
Okay, perfect.
Or you can also find them on their website and the DBPR website.
Remember the other questions?
The process
An
for
audit.
getting an independent audit to see where the money's being spent?
Well, I mean, wait, go ahead if you want to go.
All of the financial records of the association are open to the inspection of all unit owners or their representatives, which could be your any accountant that you engage to do that for you. Upon written request, they have to be made available to you within 10 business days.
5, technically.
Well, 10 on the outside, but
5 or 10?
5 business days. Within 5 business days, not more than 10.
Okay.
and the accountant can then go through all of the financial records, and hopefully they're all presented. If they're not, that can be a violation of the statute, which the division will also pursue on your behalf.
Okay.
So that would be the best way to go about getting an independent audit, is having your authorized representative, an accountant you retain, set up an appointment through you with the association management office or board, whoever's holding the custodian of the records.
How large is the condominium? How many units?
152.
152. And do you know what the gross budget is? How much total
That's a good
assessments
question.
every year?
No, she understands. She doesn't know.
I don't have a copy of it readily available.
Well, would you know if it's more than 600,000?
No, I can't say for sure.
Well, the statute provides for certain levels
think
of
so.
financial review the association is required to do each year. Plus, the bylaws may have a specific requirement that the association undertake an audit each year, so you could look at that. That wouldn't be required of the owners individually to pay for the cost, and the association would be required to do that if it meets the threshold.
Okay. I'll have to look and see what that figure is.
But if the owners are doing it on their own, they're going to be paying the costs.
And what was the third question?
Exactly. There was a HO6 assessment last year. Yes. And we don't see that in our general, in our monthly financials. And they stated that that's in a different account, but yet they've not released any of that information.
Well, that piggybacks off the last answer, which is that the financial records of the association, including those records, would be open to inspection and copying. So if they could redact the bank account number, for example, the routing number, that identifying information of the bank account, but the actual funds should be indicated on a financial statement. That is something that, and that you should be able to know where the money's held and how much it is in that account and how it's being spent. So that can be part of your document inspection request to inspect the records reflecting the special assessment funds, where they're being kept, how they're being spent. And if you're not getting if you're not being provided that, then as part of your division contact, you're going to inform them that they're willfully withholding financial records, and that could subject the association to monetary penalties and damages that they would have to pay to you.
Correct. But that's money that they're spending out of our money putting in.
That is also true.
Yeah. Okay, well, thank you so much for your
Thanks,
time.
Pam.
And thanks for
on the
listening.
Radio. Sure, no problem.
Let's
Thank
see if
you.
we can
Bye-bye.
get
Bye-bye.
one more call in.
Let's do that.
Let's go to Mary. Mary, are you there?
Yeah, hi.
Thanks for holding.
Thank you for taking my call. Yeah, I'm calling on behalf of a friend. She's the secretary. She's the treasurer of a condo that has 14 units. And inspecting the financials, she found evidence of fraud. So she went to the property manager, and he poo-pooed it. So she approached the president who committed the fraud, and he kind of tap danced, and so she called a special meeting to interview a new management company because nobody was listening to her, and the president is calling a recall on her now. So we don't really understand how a recall is, processed, and what can she do to fight the recall?
Well, there's a number of options available to her. If she thinks there's financial irregularities in the association accounts, as with the last caller, she can notify the Division of Condominium.
We're in the process of doing that.
And they'll do an independent investigation on that. With respect to recall, the owners can recall any board member by a written agreement that is signed by a majority.
Okay, can the president call a recall?
Yes.
Because we only have 14 units and 3 owners live and everybody else is an investor that lives in foreign countries or in New York.
Well, any unit owner can do that, including the president.
The president doesn't have the authority to remove her from the board. No board member can be removed by the rest of the board. The recall would be a majority of the membership. So at least 8 of the 14 units would have unit owners representing 8 of the 14 units would have to in this case, sign off on a written agreement, since you're indicating they're not present, and a written recall agreement. So if which can be emailed to these investors overseas, they can sign it and send it back. And if 8 of the 14 agree, even though it's on false pretenses, that doesn't make a difference.
Okay, that's what we figured out. Real quick, she never got a recall notice, so she doesn't have a right to vote?
Correct. You don't. I mean, she doesn't. Well, because she's not going to vote to recall herself. But certainly, if she has documentary proof of fraud, she can certainly use that to rally the 8 of the 14 to remove the president.
Okay, that's what we're trying to do. All right. So she doesn't vote, and another member that is being recalled that supported her. So the recalled people don't have a right to vote?
Well, it isn't a meeting at which there's a vote. It's a written agreement that says, yes, we want to recall this person. So
either recall or retain, right?
Right. So it isn't the same kind of...
Does the president have a right to sign this letter or not?
Yes.
Remember, what this recall attempt is by owners. Even though you have the president, you have a vice president, you have a treasurer, you have a secretary, those are their officer hats. They are also all directors, and that's how they vote for the board as directors. But then all of you are owners. And when it comes to the recall, you all have your owner hat on, and you're voting for or against the recall as an owner. So the president will vote as yes, or either to recall or retain as one of the 14 owners.
But then she and her friend don't have a right to vote, but the president does.
Well, they do have... If they get a copy of the agreement, they can say, we want to retain, but that's irrelevant. If 8 of the 14 vote to recall, whether she votes or not, it doesn't make a difference.
Okay, real quick, we checked the book, and it said that signatures need to be verified. Does she have a right to see the signatures?
Once the recall is properly served, if they're claiming they have enough to remove her and they kick her off the board, they would have to provide copies of those agreements, which she can then challenge.
And a recall director has the right to bring an arbitration action with the Division of Condominium arbitration section within 60 days of the recall.
Who appoints the recall director?
The remaining board members.
Wait, what do you mean? What do you mean by the recall director?
Well, he just mentioned that's one thing I read in the book, that there's a director that checks out the signatures, and he's the one that kind of...
Well, that's the... basically, the bottom of the recall agreement is the owner, is the information of the owner, and I'm just going to say it simply this way, the owner organizing the recall. And so that individual is the one trying to push for the recall. That individual is the one who'd be responsible for verifying the signatures and saying, yes, we have enough for a valid recall. Now, that's not necessarily the case, because obviously, as you're indicating, this individual has a vested interest in saying, hey, we've got enough. So that's the reason why the individual being recalled can challenge it. That's part of the legislative changes that occurred in 2017, which, in my opinion, unfortunately, would negatively impact your friend. In the past, if your friend was going to be recalled, the burden would be on the association. In this case, they're the ones trying to recall to prove that the recall was valid. But now that has been changed, and effectively, if they're claiming she's recalled and they say we have a majority, as Robert mentioned, she can go out of pocket and challenge the validity of the recall. So the burden's on her to say it's invalid, and then the association would have to prove it's valid, not the other way around. But that's how that process works.
All right.
Does that answer your question?
Real quick,
Thank you.
Thanks a lot.
All right.
Let's go to a break. When we come back, we've got Bob and we've got Bonnie.
Thanks for holding, Bob and Bonnie.
Just a minute.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaughn. a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Hey, we're back. We're back here with Robert Kaye and Michael Bender. Kaye Bender Rembaum. Let's see if we can go to the phone. Bob, are you still there? Bob?
Yes, I'm here.
Hey,
You hear me?
you're calling from Philadelphia.
Yes, I am. Well, near Philadelphia. I'm not actually calling from Staten Island, New York.
Okay.
But I am the president of a condo in Fort Lauderdale. And it's a small condo. And I have a question regarding board meetings. Let me give you the background. At a duly noticed board meeting, the board voted to paint several sections of the condo. Naturally, after a painting decision is made, there are all kinds of questions as to what color. So occasionally board members get together, sometimes a majority of the board, to discuss what color we should paint, what color we should use to paint. Do those meetings to decide on the color require a board meeting?
You're actually asking whether those meetings are required to have advance notice and allow unit owners to attend and participate as if it were a board meeting. And the answer is that as long as they're only considering and not making any formal decisions, then no. But no ultimate decision will have been made at that point, and then there would be a board meeting down the road at which there would be proper notice that they would do that.
Well, the decision has been made and approved by the board to go forward with the painting. What hasn't been decided is what color.
Yes,
White,
I understand.
Okay. So you're saying that after the board, after we need a board meeting to decide whether it should be black or white? Is that what you're saying?
Well, if you're changing the color that it currently is, that is considered a material alteration to the common elements that may require a vote of the unit owners, depending on how your documents are written.
Right. Our documents do state that it was a material alteration. It does require actually, our documents say if it's a material alteration and that alteration is more than $8,000, then it does require owner approval.
Right, then that would not, because one color costs the same as another, so there would not be an $8,000 expense for the color change, so the board would be able to make that decision on its own. But it would still need to be either at a formal board meeting or by a written resolution signed by 100% of the board.
Presuming your documents read as you just expressed.
I'm sorry, say that again?
No, presuming your document that all the material alteration provision is one that does really, it is recommended that you have that reviewed by an association council and get a written opinion as to whether a membership vote is needed before you proceed, especially with that other change in the law, which says that you need a vote in advance of undertaking a material alteration if the vote is required. So if the way you summarized what your provision states, it would appear to us that it would not require a vote of the membership, because painting it white costing $50,000, painting it black costing $50,000. So there is no $8,000 charge for the alteration, the white to black or black to white. But that's if your documents are written in a way that would allow it to be interpreted reasonably that way. But any vote to approve the color should be approved at a properly noticed meeting of the board. So if you approve the painting contract, but part of that painting contract wasn't which color, then you need to come back and approve the paint color at a board meeting. Especially if it's going to be a change.
Well, suppose it was white and we're going to repaint it white.
Then you don't have to approve it at a board. Then you've approved the repainting of the building and it's the same color. You're fine. But if you're going to change the paint color, that would need to have a discussion and approval at a board meeting, in our opinion.
Well, assuming that our current documents are valid, that would only be that would only be if the duration is more than $8,000.
No, either way, the board should be, if you're changing from white to black, and you did not approve that when you approved the contract, then and you've discussed it subsequent, then you should have a meeting where the board motion is made to approve the painting of the changing of the building color from white to black.
Got it. Okay.
Thanks, Bob.
Help. Thank you very much.
All right, good luck.
Let's take one more. Bonnie?
Yes?
Okay, you're still with us. You have a question for Robert and Michael?
Yes, I do. I have two, actually. The first one, when a homeowner decides to put an addition onto their house, single-family homes, in a HOA, say, example, a Florida room, they go ahead and put the Florida room on, then find that they needed a city permit, City of Coconut Creek. Okay, they did not get HOA approval. No ACC form was completed. No one was consulted on the homeowners association. The construction went ahead. It was then seen and reported to the property manager. Come to find out, they then went through the back door to get a City of Coconut Creek permit, which the building department said we aren't required to get HOA approval. Where does the HOA stand on this? Because it's still not ACC approved.
Well, your documents are enforceable by the association against the homeowner who has violated them. The issue of the permit is a city issue, and the city is the one that enforces that. Some cities won't give a permit unless they get association approval. Other cities do not, such as Coconut Creek, as you've identified. So they're leaving you on your own with that. But you have the entitlement to enforce your documents against the violating owner who did not seek prior approval before undertaking the alteration. You can bring it to litigation if that is the desire of the board, but the first step would be to have the association attorney send a letter identifying the violation and give them an opportunity to submit an application. If they submit all the necessary documentation and there's no reason to deny it other than the fact that they started doing it before you approved it, then we'd suggest you go ahead and approve it at that point. But if there are issues with what they're doing that would be in violation of your documents or your architectural standards, then you
will not approve it.
You could not approve it, and if they continue with it, you could bring legal action against them to compel them to remove it and put it back to the way it was, or bring it into compliance.
And reimburse you your fees for having to bring that action.
Thank you. That's the first one. The second one is the following. If we have pavers, brick-style pavers, as part of our entrance, our in and out traffic lanes, is it considered a material alteration to the common element to change that to asphalt?
Well, you're not a condominium, so you don't have common elements. And material alterations is not an issue as it would be in a condominium. It all depends on how your documents are written, your declaration of covenants. These are common areas, which is a distinction from common elements in the law. Common elements applies just to condominiums unless your documents create that terminology. So in most instances, homeowners associations in Coconut Creek typically are able to make alterations without having to submit it to a vote of the owners, but your documents will need to be reviewed by your association counsel to answer that question for you.
Thank you.
Sure.
Thanks, Bonnie.
Okay.
Thanks for listening.
See, this is why you need a law firm that specializes in this. There is a lot to know.
Listen, that was 4 people who asked very good questions,
Yes.
and there was a gamut of topics, which, as you can clearly
That
hear,
was
this
just
is
4.
right, which is what we do on a daily basis, addressing all issues that come up and trying to come up with solutions and options. And our role as counsel is not to give business advice. That's why you either you're board members or you have a good management company who's there to help guide you on the business side. Our role is to provide legal advice. And in order to best do that, it's important that these volunteers and their managers recognize that this is a corporation that needs expert advice in the legal arena when it needs expert advice in the legal arena. Just like if you have an insurance-related issue, you'd go to your insurance agent. The audits, you'd go to the CPAs. Well, there are a lot of legal issues that come up, and you need to go to your legal counsel. You need to have a budget in your line item for legal. And every owner has to put a few bucks into that budget out of their part of their maintenance assessments so that there is a pot, a kitty for addressing legal issues. And then you get experienced counsel. And what we do, at least in our firm, is we get all the facts, as much of the facts you saw. You can see Robert and I trying to pull additional facts so that when we're providing guidance, we're saying, here's your options. Here's pros and cons of option one. If there's a second option, pros and cons. A cost-benefit analysis. Recommendation, if there's a recommendation to be made. Then board members can sit around their table with their management team and discuss the business aspect, being a fully informed board. Now, we've done our job. We've made them fully informed, and they can go ahead and make a reasonable business decision being fully informed. And that's the job.
They have good information.
And that's right. That's the role of good corporate counsel in the association setting, and that's what KBR, Kaye Bender Rembaum, does. KBRlegal.com. You can reach out to us there.
Hey, we're going to go to break. If you'd like to call in, the phone number here is 888-565-1470. 888-565-1470. We're going to go to break. We come back. You've got
lots of classes coming up.
Lots of education.
We'll be right back.
Yeah.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back. This is the Ask the Expert Show. Well, this is the first Thursday of the month, so that means this is the Kaye Bender Rembaum law firm, and you're doing a lot of stuff now this month.
Kaye Bender Rembaum Comedy Hour. Yeah. We actually are doing quite a bit. In fact, we are. You
give back a lot. I got to tell you guys.
We are teaching, and there's a class tonight in our Pompano office that our friend and colleague Andrew Black, shout out to Andy, is going to be teaching the condominium board member certification class starting at 6:30. And I do know that there are a few spots. It was pretty good attendance was that when I left that had pre-registered. But we do have a few spots. So if anyone wants to go down, and they should call. They could call the office at 954-928. Yeah, they are 954-928-0680. Because we're doing the class tonight, they will answer the phones. Otherwise, because normally after 5:30, receptions go home. But it's our office in Pompano. It's off of Copens and Andrews. If they're interested. And then that is actually, and I also want to add that Florida Community Bank is sponsoring that class. And I want to thank them for that. And they're going to be providing some great information about banking. And they do a lot of banking with community associations. So I wanted to thank Florida Community Bank. Later this month on September 25th in Pompano, we're going to be doing the board member certification for homeowners. So we have the condominium board members tonight. Homeowners will be in a couple of weeks. Florida Community Bank is generously sponsoring that as well. So in addition to coming out and getting your board member education, you'll get to speak to a very experienced vice president of the bank who they do community association related banking business, anywhere from their lockbox process and banking to borrowing, funding projects, etc. So Florida Community Bank, want to thank them again for sponsoring our classes in Pompano.
Considering becoming a board member, these classes are very important. They have to have them, right?
Look at you learning.
I have learned so much.
Well, that's true. As a board member in the state of Florida, whether you're on a condominium, cooperative, or homeowner association, you are required to have board certification within 90 days of being elected or appointed to the board. That certification comes in one of two ways. There is a form that the Division of Condominium created, and that's good also for HOAs. They also created one for homeowner association board members. And that form you can sign that says you've read your documents, you promise to uphold them faithfully, fiduciary duty, etc. And so if you cannot get to an education class within the 90-day period of being elected or appointed, sign the form, be in compliance. However, the other way, which is recommended, is go get your education. We offer this free education in both of our offices. We have our office in Palm Beach Gardens has great, Jeff Rembaum runs that office, was experienced attorneys, several experienced attorneys that work with us up there. And they teach the Homeowner Association board member class this month on Wednesday, September 12th. And then they'll be doing the condominium board class next month. Later this month, in Palm Beach Gardens, they're doing the legal update. And that's the 2019 legal update, which is going over all the legislative changes that occurred this year in 2018. And so they're going to be teaching that out of Palm Beach Gardens on September 26th. The classes in Palm Beach Gardens start at 6 p.m. The classes in Pompano Beach start at 6:30. And I encourage everyone to go to our website at kbrlegal.com, kbrlegal.com, and we have all of our class information there. Everything's free to attend. We offer some snacks as well. And the education is outstanding. Great attorneys teaching these classes in both offices. So that's very much encouraged. We already have our October schedule up there as well, which we can talk about later if we have time. But I do want to also point out that the beginning of next month, Kaye Bender-Rumbaum is a proud partner with the Palm Beach, Broward, and Miami-Dade County Expos. It's the L&L Expo group that has been doing these expos in Palm Beach, Broward, and Miami-Dade for several years, and we've worked with them. And we attend, and we are proud to attend and teach at all three. Will be Palm Beach County's first, and it's Tuesday, October 2nd at the Palm Beach County Convention Center. Broward County is next that same week, Thursday the 4th at the Broward County Convention Center. And then the following Tuesday, the 9th, is Miami-Dade. So this year, they're all three within a week's time. The 2nd of October, the 4th of October, the 9th of October, Palm Beach, Broward, Miami-Dade. And the Miami-Dade's at James L. Knight. And we're going to teach two classes at each. In Palm Beach and Broward, and then one in Miami-Dade. We'll be teaching a class on covenant enforcement in the morning starting at 10 a.m., and then I'll be teaching the 2019 legal update in Palm Beach and Broward at 2:30 to 4:30, as well as in Miami-Dade 2:30 to 4:30. So, like I said, in Palm Beach Gardens, Jeff and his team will teach the legal update on Wednesday, September 26th, and then you can also come and hear it in Palm Beach on Tuesday, October 2nd, Broward on Thursday, October 4th, and Miami-Dade on Tuesday, October 9th. In addition, the expos are outstanding ways to come. We have a booth out there. You can come and see us all day. We have attorneys who will man that booth and be available to answer questions.
Free to attend?
It's all free to attend. And if you let us know you want to come, we'll give you an invitation. You can have lunch on us, on Kaye Bender-Rumbaum. And we have our experienced attorneys who are at these booths all day. We encourage our clients certainly to come by, say hi. And if you're looking for a new counsel or additional counsel, to stop by, learn more about who we are, what we do. We'll set up a free consultation, come meet with you in Palm Beach, Broward, Miami-Dade. We're happy to do that. So that's a lot of what's going on. And again, kbrlegal.com has all of this information, and I encourage everyone to go there. If you're looking for more information or you want to RSVP to anything, you can. And there is information on the website where to do it, or on the main screen there's a box where you can send to info or you can just email info at kbrlegal.com, and just give us your name, your contact number, your association, and what class you want to attend.
Well, I got to tell you, it's so you make it so easy, and you'll be teaching, and
I'll be minding the store.
Minding the store,
right? And he'll be here.
It must be really big because they have them at the convention centers.
They are. They are. Well, I guess, yeah. There's, again, when I say that, there's a trade show floor, and so for board members or managers who are looking for, contractors or looking for
all sorts of service
any sorts of service. There's numerous service providers, tons of them. Condominium associations who are now required to do websites. If your condominium itself has 150 or more units. Then you are required to have a website in place by January 1st of 2019. I'm fairly confident there'll be a few companies there who offer such a service, and you can get a demo and review it, and then come by our booth and ask us what we know about it, because obviously any contract you want your lawyer to review. But yeah, so there's probably close to 100 vendors, I would guess, at these exhibit halls, and like I said, and education going on throughout the day. So there's an opportunity to go to our classes, and then go by the exhibit hall and visit the vendors who, as vendors, we sponsor. And so, of course, come by and see your vendors, and go to classes, but come by and spend time and see the vendors and get some good information about people you might want to hire down the road for your association.
I want to throw my 2 cents in because, listen, you've listened to the show long enough. There is so much to learn. Don't try to do this yourself. I mean, it's one of those, you can either pay me now or you can pay me later. If you can't tell, these guys really know what they're doing, and they make it to where we can understand. And, I'm seeing more and more that we're getting presidents of association, board members calling in, and they sound like maybe they should be talking to you. So I put my 2 cents in. One of the things we've done, we got a few more minutes before we go to break. We have a couple open lines if you want to call us at 888-565-1470, 888-565-1470. So we put out for our show every week, if you have a question for our guest, and for some reason, about 2 weeks ago, wasn't even your week for the show, we got about 10 or 12 questions in.
Twitter blew up.
Unbelievable. It wasn't even usually it's around the showtime. So I'm going to ask you a few of these questions, and
let's start with one.
Okay.
We're getting close
I was
to
going to ask 3 at one time. So if permission is granted by a board member, is the association legally stopped from enforcing a governing document?
Well, the question. Well, I figured you were tired from all the other stuff.
I forgot my energy drink.
That was good, though. I got a minute. It's good.
Unfortunately, that's not written in a way that I can say yes or no, because there are many factors that can be involved in this. What the covenant enforcement is that we're dealing with, how the permission came about. Was it something that created in a reasonable person the expectation that the person had authority to grant the authority, the approval, whether they knew or should have known that there was a process they needed to follow? There are cases in Florida where a board member granted a verbal approval to somebody to do an alteration on their home. The person knew there was a process where they were supposed to submit a written request and get a formal board approval in writing. And the court said by knowing that, the association could enforce its documents, notwithstanding the fact that this rogue board member had given permission. But the facts of the case are definitely important and will be a factor in deciding whether or not that is the case. The legal principle involved, which is called estoppel, they use the word stop, means that if somebody relies to their detriment on what the board member has told them, and it's reasonable for them to have done it, and they're damaged as a result of it, that could preclude the association from enforcing its documents.
Okay. I guess it looks like I'm going to have to save these questions for next month.
Well, we'll see.
The phones are blowing up again.
We'll keep them in our back pocket.
Let's go to Laura.
No, let's go to break.
Want to go to break?
That's at the last breakout. Okay. Laura, hang in there.
Yes, we'll be right back.
It'll be 10.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back for our final 15 minutes. We got a couple callers on the phone. We've got Robert Kaye and Michael Bender. Kaye Bender Rembaum. Let's go to Laura now. Hi, Laura.
Good afternoon.
Hi, Laura.
Did I jump the gun? Thank you for taking my call. I live in an HOA, and a lot of the homeowners here have been here, 20 years, and several of them have bird feeders outside, or what else? Well, I guess the big thing is bird feeders and feeding squirrels. Now, at a meeting last night, which was not a regular board meeting, the president announced that anyone that feeds birds here anymore is going to get a $100 a day fine. We don't have that in our documents or rules. Can they just announce that at a meeting and enforce it?
Well, they can announce it at the meeting, but it doesn't sound like something that's legally enforceable based upon the facts that you have put forth. In order to prohibit an activity, there has to be something in the documents that allow for the prohibition. And considering that these have been in existence for an extended period of time, they can't just suddenly start enforcing on people that have been doing this. Even if it was in the document, there's a procedure they'd have to go through. If a violation of your covenants has been allowed by the board to be ongoing for a period of more than 1 year, then the association can be found to have waived that restriction and will not be able to get a court order to enforce it if the defense is raised by a homeowner in the case. Nuisance is another type of issue that can be used, but that one's more tenuous under the circumstances because, again, these bird feeders have been there for a long time and they're more decorative than functional, I suspect, but I imagine some birds come around anyway.
Right.
The feeding of, you said feeding of
squirrels.
That is something the board can adopt a rule that prohibits the feeding of wild animals, assuming they have the authority to make such a rule in the governing documents itself, and on a going forward basis that could be enforceable, but it's kind of hard to make that case. With respect to the fine that the president is seeking to impose, the statute requires a procedure be followed in order to impose a fine, and first there has to be a notice to the owner of the violation and then an opportunity for a hearing before an independent committee to determine whether or not the fine is in fact going to be imposed or not. The limitation is $100 per violation, with each day being a separate violation, up to a maximum of $1,000 unless your documents allow for something higher, which I suspect they do not.
No, they don't.
So, and unless the documents allow for it, the fine would not be an assessment against the home.
Well, can they just make a rule, like say at a board meeting, they say we have a new rule starting today and it's going to be this? And from that day on to have it.
Well, not without proper notice, at a minimum. The rule you're talking about is impacting the use of your parcel or your lot.
Right.
So the Chapter 720 or a Homeowner Association Act would require that 14-day notice be provided to all owners, mail or hand delivery, or electronic if it was consented to, of notice of that meeting where the board will consider a rule that is going to impact the parcel. Okay. If they've provided that proper notice, then at the meeting they can discuss and adopt the rule, but as Robert said, that presumes they have the authority to adopt such a rule, which would be set forth in the governing documents.
And isn't there then a 30-day notice requirement?
Is that new?
Subsequent? I think that's new. It's either new or proposed. It's hard to keep them straight.
Yeah.
Okay.
Okay.
But they can't just do what you've described.
And there may be, if in fact they have the authority to adopt the rule and do properly do the notice, 14-day notice has to be posted and mailed, and then properly adopted, there may be other procedural requirements and or document requirements saying that, hey, once the rule is properly approved, it has to be published to the membership. Well, that's for sure, and it may not take effect for a certain number of days after. But all of that procedural stuff would be, dictated by the governing documents,
Right.
and that's how that would work.
But would that affect the people that have been feeding the birds for the past 10 years?
Rules cannot be applied retroactively.
Meaning they can't go after the people that have the bird feeders hanging there.
They can't make a rule that says you can't have a bird feeder and then tell these owners who've had bird feeders for 20 years they have to remove them. I think they would have a problem with that. Do you agree?
Right. Well, thank you so much.
All right. Thanks for
Laura.
listening.
We got another caller. Hi, Danny. Is Danny?
Hi guys, just a quick comment to the listeners and to that. I met Michael in this firm at one of those recent seminars, expos, and had a great experience learning from his 2018 legal update. I serve as secretary on a board, and loved what this firm offers and its knowledge so much that I chatted with Michael and have. I'll admit, have hired the firm to represent our community, and it's been
Good
such
decision.
a wonderful blessing all the way around.
Good decision, Danny.
Michael's
Thank you.
uncle.
Thank you for the words.
No, I took. Hi, Danny. I wasn't sure who it was at first. Thank you. Yes.
So I just wanted to encourage everybody to. This is a really good firm. It's done wonders for us in our community and our association. So thank you guys, and that's it.
You're a good guy, bro.
No questions today, eh, Danny?
No question. Just a really good comment of encouragement.
Thank
Okay.
you.
Well, thank you.
Appreciate it.
Have a good day, guys. Thanks
You
for
too.
what you do.
Keep
Bye-bye.
listening.
That was nice.
That was nice.
For the record, no idea that was coming.
Wow.
That was very nice.
But call in next month, too.
So,
So-
Michael,
Anyway,
this
but
is your
no,
part.
Yeah, well, so I want to go back and reiterate, and I do actually know that Danny's right. He attended the 2018 legal update, which I taught last year, and was able to get a lot of good education. Community that he's talking about is a lot of the communities that we've been introduced to.
Became a client.
They had not only that, but they had some challenges and they needed some guidance, and they were, they were in a situation where I think they were wanting to look for either new counsel or additional counsel and try to get better guidance, and it's working out quite well, as it almost always does when you hire Kaye Bender Rembaum. Can't say 100%, but
Well, that
that's
brings up the
definitely honest.
point. If an association has an attorney and they want to check another attorney, it's not an exclusive contract. They
Right.
can compare how we will function against the one that they're currently using and see if perhaps they like one better.
Great
Apples to
example.
apples, and we will put that out there at any time. It doesn't cost. We do not have an annual retainer fee to retain the firm as general counsel. So if you want to know, if you're looking for a second opinion, or you say, hey, we have this particular contract, we'd like you to take it on and review it for us, give us a gig, we'll do the work, see what you like. If you like it, give us more. And we're confident, because that's absolutely right. But do come to these expos. Like as I said, if not to say hello, you certainly can do that. But also to get some great free education. Palm Beach County Expo Tuesday, October 2nd, and Broward County Expo Thursday, October 4th. Got to hit those two hard because we don't have, the next time we have a show, it'll
Right,
be those
exactly.
will be passed. So Palm Beach County Expo on Tuesday, October 2nd at the Palm Beach Convention Center, and the Broward County Expo at the Broward County Convention Center Tuesday the 2nd, Thursday the 4th. We'll be teaching covenant enforcement from 10 to 11 a.m. We'll be teaching the 2019 legal update from 2:30 to 4:30. In between, there's some other classes you could consider taking, as well as visiting us and many other vendors in the exhibit hall. If you email me at info@kbrlegal.com and are interested in attending the expo, I will try to get you a free lunch on KBR. Kaye Bender Rembaum. But L&L Expo, they put on a great program. We're very happy to be working with them over the years. So do come out to those expos. In addition, come to the free education in Pompano and Palm Beach Gardens. Like I said, tonight's the board member certification in Pompano Beach. Tuesday, September 25th is the board member certification for HOAs. Florida Community Bank, an excellent community association bank, has been generous enough to sponsor that. And so come out and also get some great information on their bank, as well as just on banking for community associations. I think that's a great aspect to it's just additional education and information that we provide to anyone who comes to our classes. In Palm Beach Gardens, they're going to be doing the HOA board member certification course on Wednesday the 12th, next Wednesday. And then Wednesday the 26th will be the 2019 legal update. And space is very limited in Palm Beach Gardens, so definitely reach out to Trisha, Trisha, Trisha at kbrlegal.com. Pompano Beach, space is limited, not quite as limited, but it is still limited. So you can reach out to seminars at kbrlegal.com. Go to our website at kbrlegal.com and you can get all of this information and know who to contact. Or you can call 800-974-0680. It's that 974 that always gets me. 800-974. 800-974-0680 or kbrlegal.com. Either of those, you'll be able to get information on us, maybe set up a free consultation. We're happy to come out and meet with boards throughout the Tri-County area at any time. No charge, no obligation, to find out what their issues are, talk more about who we are, and maybe see if it's a good fit. If you are a group of communities or management company who would like to have some education offered to your communities, we're happy to come out and put a presentation together in that regard. Free credits to the managers, great education for the board members. Just contact kbrlegal.com, and then those you'd ask for me.
And it doesn't take them, when you're a client of theirs, it doesn't take them 3, 4, 5 days to get back with you because your customer service is amazing.
Same day, we will return the call.
In by 7, out by 10. Now, thanks for coming on today. I love the first Thursday of the month. We'll see you next month, and I'll see you next week with more Ask the Experts. Thank you, Mr. Kaye.
You're welcome.
Thank you, Mr. Bender.
Thanks you all
Pleasure
for listening.
To be here. See everybody in November. Robert will be solo next month. So.
And those who attend the Broward, you can listen to me in the car on your way home when you're sitting in traffic.
And Michael just whispered in my ear to wish everybody a Happy New Year.
Happy and a healthy.
I'll call in.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its